was a slow news week in copyright, but there are a few interesting things going on, not the least of which is this decision by the U.S. Copyright Office to modify the registration, the copyright registration, the piece of paper and the corresponding electronic record that tie a copyright to a particular person. Usually costs $45 to $65. There's other fees involved sometimes, but this author, Chris Castanova, wrote a book. It was a graphic novel, and the graphic novel contained images generated by the Midjourney AI image generation engine. The Copyright Office stated that Castanova is entitled to copyright for the parts of the book they wrote and arranged, but not for the AI-generated images. The previous registration will be withdrawn and reissued, and it will now say it omits images that are not the product of human authorship, and therefore those things cannot be copyrighted. So the images are not able to be copyrighted, but the other creativity that the human person, Mr. or Ms., I don't know this person's gender, Castanova, they cannot own the things that the Midjourney AI engine created because the AI cannot own the copyright. Therefore, anything created by an AI is not copyrightable. Same situation as the monkey, the macaque, Naruto, and the macaque took the photo even though the photographer owned the equipment and had control of the image, had control of the digital file, but the actual legal entity or legal property that is the image itself was not able to be protected by copyright law because copyright law only protects creative authorship of human origin. It's funny how often the legal world and like the technological or the physical world interact. Of course, you can drive your car over the speed limit, and you probably can do it safely to a point. You can go 5-10 miles an hour over in many places without seriously making it that much more dangerous. Maybe statistically, it's more dangerous that way, but if you imagine a sober, competent driver choosing a straight section of road to go a little faster over the speed limit, yeah, you can physically safely go over the speed limit. You can physically share files on the internet. You can physically have an AI, electronically have an AI create an image for you, and you can physically control or digitally control that image to a point. That doesn't mean that it meets legal definitions for things. These philosophies of law go beyond the physical, beyond the tangible. And instead, these philosophies are sort of put in force by people observing them, by people following the code, following the creed. If we didn't observe the laws, then the laws would have no teeth, would be powerless. So, yeah, as simple as it is to feel, hey, I've created this image by choosing a prompt for the engine, and then the engine spit something out, I should own that, or the engine should own that, and that's just not true in today's copyright law. Tactical says, notably, most AI companies claim ownership of the product of the AI, and the terms of use says you can't use it without permission, which is probably only enforced when it's commercial use. Yeah, there's going to be a line there, not a well-defined line, but more like when they choose to enforce it, they get to enforce it. And it'll be a terms of use violation to use an image that you didn't have permission to use. It won't be a copyright violation since the image can't be copyrighted. But I imagine it still can be something protected with a terms of use. I think you can still contract around like what your behavior should be in return for the thing giving you a free, generated image or whatever. At the same time, I pay like the basic fee or something for Midjourney, because I'm playing with it, and I would like to know that I can use my image if I generate something that I like. I'm gonna go ahead and say I can probably get away with using an image that was created on the Midjourney engine. I doubt they're going to make a legal claim against me unless I'm really infringing. Like, has to be well over the line is my guess. But nobody quote me on that one. Unless of course I get sued by the people creating Midjourney. And then they're like, "Hey, let's use this video in your deposition as evidence against you." How about this hypothetical? A company, say Disney, writes its own AI and then runs its data set against Disney's corporate IP. How can Disney not own the AI content now? Okay, so you're saying that they fed their own copyrighted content into an AI, and then the AI spits out something that is obviously going to be derivative of Disney because that's all it's been fed. That's all of its source material. So it's going to spit out, a half mouse, half duck character or something like that that looks like Mickey and Donald. Okay, I get it. How would they not own the content? Well, that's a good one. They wouldn't own the output because that can't be copyrighted, but they would still own the inputs, and therefore they would own any part of the output that is strikingly similar, substantially similar, or actual copying of the original. So if there was an image of Mickey and Donald, fighting, like put up your dukes kind of thing, used as a source image, and then the output was some abomination combination of that, the output wouldn't really be something that Disney would own. So the resulting image, the four corners image, but somebody else couldn't go ahead and use that because it would still have contained something substantially similar to Donald and Mickey in the original, in the source, the thing that was fed into this hypothetical AI. So you could still get to ownership of the input side, I think. The problem isn't with who owns it, it's whether it can be owned at all. Yes, owned is one thing, controlled is another. So you had the reverse of this. You had Getty Images selling images that were in the public domain. There's actually nothing wrong with that. There are lots of companies that sell things that are in the public domain. I can take court documents and put them onto a private website and sell them, court listener. Even if it's a nonprofit, even if it's not, for a nefarious purpose, like you can do that, and that's a good reason to do that. Getty Images was taking public domain images and selling them on their website as well. I think Getty got in trouble because they were selling rights to the images and not just the images themselves. And you can sell what you have. You can't sell what you don't have. So you can't sell rights to the images when you didn't have rights to the images in the first place. The way I've seen lawyers get around this is saying something along the lines of, we're transferring any and all interest that you have. It does not saying, I have 100% interest and I'm transferring 100% interest. I'm transferring 100% of the interest that I have, is the way I've seen that done. So where was I? AI can't own. They're going to end up almost having to change their ruling on AI-generated stuff. Well, it's not. Okay, so here's how these rulings work. When the Copyright Claims Board or the Copyright Office, the registrar, or a judge decides that copyright law says X, Y, and Z, they're deciding what the law, the written law plus case precedent says, and they're not supposed to create new law out of whole cloth. They're really not supposed to create new law at all, and judges will strongly favor ruling on existing text than trying to create their own new law And the farther you get away from the text, the weaker that argument should be. So when you say that they need to change their ruling on AI-generated stuff, they can't rule differently because the law is clear enough. There isn't some vague wiggle room in the way the law is written that allows them to say that a AI can be an owner, or that a human can be owner under like the work for hire doctrine. I hired the AI to do it, and therefore it's my property. That's fine. The problem isn't that you were in control of the AI. The problem is that the AI is doing the creative function now. They've taken the creative function away from the human. If I want a particular scene, I had the hypothetical of Mickey Mouse and Donald Duck before, fighting fisticuffs. If I want that scene, it's my creativity that I have to draw it with my own hands, or my mouse and my computer, and put together images and composites and whatever. Use Photoshop or use Illustrator. Those are all things I have to do with my hands. There, we have drawn a philosophical line between using those individual tools, each with basically one major function or one very tightly related set of functions, and gone to this generative AI where you just ask it for something, and if you ask it properly, it will give you something very close to what you imagined. It's like, here's the best analogy I can think of. When you go to the amusement park with your family, and there's the artist, the caricature artist, and you say, I want you to draw me and my family, in a funny pose. You are not doing the creation there. You are communicating what you want the creator to do, and then the caricature artist is going to do the creating with the pen, pencil, brush strokes, whatever, and create this simpler, complex caricature. And very technically speaking, because there wasn't a written work for hire agreement, you don't own that caricature image that they then hand you. You own the copy that they handed you, but that's it. Technically, you don't own the image, and you can't go make a copy, and you can't legally take a picture with your phone and send it to your family and everything, send it to your friends, post it on Instagram, unless you have the permission, implied or expressed, of the caricature artist. So maybe that's the best analogy for these AIs, is if I go to a caricature artist and ask them to create the scene, and I go to an AI engine and I ask it to create a scene, the AI has created it, the caricature artist has created it, but only one of them is a human, and only humans can be authors for copyright law. So that's how you get to only humans can create these images, and AIs cannot create these images. And the AI not being human also means it can't own anything, because only humans can own things. So we're stuck with this. AI can't create copyrightable material. You can own what you create from the AI material, but you can't own the AI generated output. It's not human, therefore it can't create copyrightable material. How about the Dutch Marechaussee?
Marechaussee.
They created a border control cat for April Fools, but because of limitations of text, they still had to Photoshop and edit the image. To display douane on the cat and imagery, since now a human was involved, could it be copyrighted? Yeah, you're still on the right track, but we're still missing one fundamental piece, and that it's what you add to it that creates a copyrightable image. The image that the final image that contained both the AI input and the human input is copyrightable, but there would be, in the description of what is copyrighted, there would be an exception. What is not copyrighted would be the AI generated content. So the thing generates this border control douane cat for the Dutch April Fools, And whatever the AI created, that's not protected. What they added then is protected. And in the final image, I know that you can't just look at an image and tell what's copyrighted and what's not. But legally, if there was a dispute, there would be an evaluation over what's copyrightable and what's not. And it would be what they added, what the human added is copyrightable and what the AI added is not. Anyway, so that is all I have for you today. Thank you very much for your support. Especially thank you to my current supporters in April here. Eevi, Ugly Grill, Torpedan, PureMagma, Eric Tams, Gutbrodj, TechTechPotato, King Aries, and Kyle Siefring. Thank you very much for your support.